Yeah, sorry, didn't notice my name on the list here as the chair. Okay, so you all know the drill. We have Amy Powell talking first. We've got an hour and 25 minutes or something like that, so that's about whatever if you do the maths. And you're going to talk for what? 20 minutes or something like that?
Yeah, that would be fine.
Great, okay. I will start begging things.
Yeah. So sorry for not having a handout or a PowerPoint, but the good thing is I think I can finish well within 20 minutes. So the paper is actually a critique of the theory that discusses justifying distributing state liability to citizens. Okay. So when the state commits a wrongful act, for example, when it wages an unjust war, certain attendant liabilities, for example, the responsibility to make war reparations, often default to the citizens. So we can easily make sense of this when the citizens actively endorse or support that state's wrongful act, or when the citizens voluntarily participate in or contribute to that wrongful act. However, it's easy to see in these cases, this is not always the case. And so, when this is not the case, what can explain and justify distributing state liability to citizens? So, in this presentation, I will critically assess a recent theoretical approach proposed by John Parrish and Stills that appeals to the social contract theory, the idea of political obligation, to justify distributing state liability to citizens. So, and I will call this theory the authorization model. The idea of the authorization model is that although citizens do not voluntarily consent to or authorize the state's acts, they would necessarily do so. They would necessarily authorize those acts the state makes on their behalf, insofar as they are an exercise of their rights. Insofar as that act, is an exercise in the correct interpretation and enforcement of their rights. So why? Because citizens necessarily confer to the state the power of interpreting and enforcing their rights, because private judgment, private interpretation and enforcement of rights is self-defeating. So we need the state, on this traditional thought, we need the state as a unique arbitrator and enforcer of rights to resolve conflicts between private claims. Moreover, according to Parrish and Stills, that the citizens necessarily authorize the state, in this sense, means that they own also those actions that the state make, on their behalf, allegedly at least, and are to this extent liable for them. So the key to applying this principle of necessary authorization would be to figure out when the state's act qualifies, the state's act is exercise of their rights, Precisely, the key is determining when a state's act that factually violates rights can qualify and pass for an act that exercises rights. Why? Because in question are state's acts that are factually wrong, that factually violate rights. For this reason, that liability is incurred. So this is the focus of my paper. I will be undertaking a sort of internal critique of this theory, because another internal critique of this theory, in the sense that I will criticize that they have not been able to resolve this tension between the injustice of the act in question, whose liability is at stake, and the authorization view, their view that an unjust act should not be necessarily authorized. So there's this tension, and I'm saying that the factor is like this. So the key is what states and which states acts can count as an exercise of citizens' rights. So Parrish under-explains its minimal conditions. I'll come back to this. Stills, at the beginning, proposes what she calls the criteria of a democratic legal state. That so a democratic legal state satisfies a number of rights of the citizens. But I will put this aside for the purpose of this presentation, because Stills' criteria for a democratic legal state do not cover, in the way she formulates it, do not cover those states' acts that violate rights, when, as I've stressed, it is precisely those acts whose liability is in question. Stills is actually aware of this difficulty, so she anticipates the following objection. So I quote, "It would seem that if a war is unjust, citizens themselves do not have the right to wage it, and so when the state undertakes such a war, it is acting outside its mandate. If citizens can only be held responsible for the state's acts when those acts are an exercise of their rights, then perhaps they can't be held responsible for such a war at all." So end of quote. So how does Stills respond to this objection? Her response is she makes a distinction between, I quote, "mistakes that show an authority is not interpreting justice at all, and other kinds of possible mistakes that an authority might make." Okay, so simply she's saying that there are mistaken state facts that can be interpreted, that can be regarded as interpreting rights. The problem, however, is that Stills in her article never fleshes out how exactly we can distinguish between these two kinds of mistakes. So this invites Andrew Bagby to attempt a reconstruction of Stills' account. And on Bagby's reconstruction of Stills' account, the difference is that between mistakes that are not excusable and those that are. So to illustrate this, I refer to an example made by Bagby himself. So a democratic legal state receives intelligence that an evil regime is going to attack it. And so, having scrupulously checked the veracity and completeness of the intelligence, the state decides to declare war on grounds of preemptive self-defense. However, it turns out that the intelligence was false. Okay, so liability is incurred. And so, in this case, Bagby says on Stills' account, the liability will legitimately be distributed to the citizens. So I think this is actually a very smart move, and I will use it again. But Bagby himself stresses that this argument is empirically implausible. So according to him, there are few or no cases in reality where the state is excused for its wrongful acts. So, well, I think this is questionable, but there are few cases, that's for sure, I think. Well, in any case, in Bagby's words, the American invasion of Iraq in 2003 cannot in no way can count as an excusable wrongful act. But this is what Stills has in mind in her article. And the second problem is that, Bagby's interpretation is simply textually incorrect. Stills clearly thinks that an inexcusable states act can still be deemed as protecting rights, and whose liability would therefore be, distributed on the very terms of the organization model. So, for example, she says that state agents responsible for the act in question may well be morally blameworthy or indeed charged as war criminals. Stills seems to have another answer as to why inexcusable violations of rights can pass for acts that protect rights. It is to transpose the object of necessary authorization from the particular wrongful states act in question to the state as an authority in the whole. So I quote, "We do better overall in securing our rights than by substituting our private judgment for the authorities. This is true even when in this particular case, the authority's judgment about our rights is incorrect. The overall gains to the security of our rights outweigh the possible better answers as to what our rights might require in this case." End of quote, so this is from Stills. In my opinion, so here comes my critique. So there are two problems with this approach. One problem is that Stills, as well as Parrish, does not specify how far or to what extent the state's mistakes are to be tolerated in light of overview. I will come back to this. So assuming that the state's mistaken interpretations of rights make up only a small portion of its overall undertakings, there's still another problem, I think. Namely, Stills does not explicate why we would necessarily do better overall in tolerating these instances of incorrect interpretations of right and owning up to these actions, accepting liability for them. The implicit argument seems to be that in challenging the state in these particular cases, scanty as they are, we will undermine its general authority and thereby its authority to enforce rights in cases where it does so correctly. And and assuming that these cases of correct interpretation constitute the majority, I think this is an empirical statement that requires verification. So because of the corporate nature of the state, presumably the contrary will be true, and that is the long-term, the effectiveness of the state as an enforcer, interpreter of rights will be strengthened and improved in the long run if we do not accept its wrongful or sometimes even malicious acts in these particular cases. So, yeah, so I'm saying that the state's corporate nature will make it resistant to change. So if we accept, liability for them every time, this is not going to help them learn their lesson, okay, as it were. Okay, so turning to the other problem, this does not spell out the limits within which a state can violate rights and still qualify as a worthwhile authority on the whole. So to put this another way, to what extent would we tolerate those acts in view of overall gain? For example, Stilts states that Jose Padilla, a U.S. citizen who was designated an enemy combatant and held for 3.5 years without trial, would not necessarily authorize the state of America as his agent, because the state of America was not credibly exercising his rights, and he therefore should not liability for the Iraq War, for example. My misgiving about this analysis is its incompleteness. So still hasn't told us why Jose Padilla's own acceptance of this particular act of violation against him will not secure for himself, for Jose Padilla himself, overall gains. Vagueness in these matters, incompleteness in these matters will only lead Stills' account doubtlessly proceed toward unqualified and blanket authorization. I think this problem takes on a radical and extreme form in Parrish's own rendition of the authorization model. So, like Stills, Parrish intends the object of necessary authorization as the state, as an authority in the whole, rather than the particular state act whose liability is in question. So in Parrish's words, I quote, "This sort of authorization is granted to the state as a general power, rather than licensed to it on a specific case-by-case basis," end of quote. So according to Parrish, to what extent would this sort of authorization be granted? Quote again. To the extent that the state is engaged in doing those things that all states do on behalf of the citizens, which any state would do on behalf of the citizens, then even citizens of non-democratic states remain responsible for the outcomes. But as the state's actions go beyond this threshold into other more voluntary spheres of policy choice, for example, adopting a pattern of military aggression or of internal oppression, the moral responsibilities of non-democratic subjects diminish accordingly. So according to Parrish, end of quote. So according to Parrish, anything slightly better than adopting a pattern of military aggression or internal oppression will render the state's status as a worthwhile authority or as a bona fide agent of citizens unchallengeable. Actually, even doing so, I might be uncharitable to him here, but allow me to say this. I mean, even doing so will still not disqualify the state. It will only diminish its authority. So this is how I read Parrish. And I think this is really to accept any state that it's just slightly better than adopting a pattern of military aggression. That seems rather a bad scenario. Well, much of Parrish's effort is put on asserting that the right kind of connection between the citizens and the state obtains. So he claims that, I quote, "There may be many available means for me as a citizen to mitigate my responsibility for my state's actions, but it will be vastly more difficult on the authorized state account to eliminate it entirely," end of quote. But then the question is, under what circumstances is my responsibility for my state's actions eliminated entirely? So the question is not answered. And if the answer is no, it's never, the authorization model fails, I think, because it fails to distinguish between partially a wholly authorized state and unauthorized state. Okay. So basically that's the main part of my paper. this is an internal critique. A number of philosophers, including some present here, A.K. Pasternak including, I think, can correct me, conducts, I think, a sort of external critique, saying that necessary authorization is not actual authorization, because no voluntariness or control is actually involved in, in the model they're proposing. And I absolutely agree with this. Yes, and also, so for example, Robert Jupp, so he draws attention to the fact that necessary authorization in in the theories of Stills and Parrish actually denote a sort of relation of guardianship. So actually Stills is pretty explicit about this. So Stills compares citizen-state relation at one point to the relation between a child and his guardian who holds his property in trust. So for that matter, so I'll pick up Jeff's point from here, is that for that matter I think it's inappropriate to compare the relation between adult citizens and the state with child trustee, a child guardian relation. But I think we may characterize the relation between children and teenagers with the state, the relation between teenagers and children and the state, as one of guardianship, okay, as a relation of guardianship. So an example would be, so there's some, recently, there are some cases of climate change litigations where teenagers in America, in some American states, sue their government. If I remember correctly, it's the state of Oregon, but there are still others, I think. Sue their government for failing to protect atmospheric resources, understood as public property in trust. But I think this argument works, in that case, because they are teenagers and not, adult citizens. But anyway, putting aside this complication and assume, for the sake of argument, only for the sake of argument, that we can that the citizen-state relation is one of guardianship. The problem is, so how does this ground collective responsibility? How does this justify, distributing liability to citizens? Because normally the guardian or the trustee would be held personally responsible and liable when it does something wrong, whether with regard to in relation to the ward, the child, the beneficiary itself, or some third parties. So here, I think I'm being I try to make a case for them is that the trustee can be held liable if he's really acting within his mandate and if the mistake is excusable. So not only does he does not intentionally or avoidably harm, and he is also not incapable. He's not being negligent, but rather there's some excuses like the case that Becky talks about. So again, I think that this distinction between acts that are excusable and those that are not is, it's relevant and can make a difference. So this is also very quickly, because I think this might be more interesting. Very briefly, I want to discuss some other possible grounds for distributing liability to citizens, and I think one of the major motivation for, I think the idea that the citizens bear liability for the Estates Act is very strong. So where comes this strong, not even intuition, I think, where comes this strong fact, is that the wrongful state actors are not capable of remedying the harm. So this is the kind of situation of responsibility deficit or responsibility shortfall that some of you have talked about in the papers and in the presentations. And so the motivation is mainly to make good this, to solve this responsibility deficit, to make good the legitimate claims of the victims. So I don't think it's an argument from the ability of the citizens. So it's not an argument of benevolence. It's not an argument from ability. It's not that the citizens are really capable, in the normal sense of the term, of remedying the harm done. It's more of an argument from the inability of the state actors. Okay, and so because the citizens are related to the to the state in many ways. Some, for example, intentional participation. Well, I don't think it's voluntary participation, but intentional participation. That's pretty sure. I think we pay taxes, and this will even very indirectly and sometimes we unknowingly contribute to, say, unjust war, and we receive benefits, through, from our state and from the exit. So it's kind of vicarious responsibility, but I don't think we need to appeal to this idea of necessary authorization, rights protection to just rest. That's it.
Egalitarianism, I'll just say, hey you instead of when I do. So, hey you.
Farid Abdel-Noor from San Diego State University. I really enjoyed reading your paper. It seems to me that Parrish and Stilts are each using a different theory of state legitimacy. So Parrish is relying on Hobbes and Stilts is relying on Kant. Mm-hmm. And it seems that what they're saying is whatever makes the state legitimate for its citizens. If a citizen accepts the state as legitimate on Hobbesian grounds, then that imposes burdens on the citizens to own what the state does. And for Stilts, it seems to me that if the citizens accept the state as legitimate on Kantian grounds, then whatever that theory of the state, whatever is allowed within that, is something that they own. Do you see it that way, and do you see something fundamentally wrong with making that connection?
Well, I do have to think. So the question is, so according to Stilts and Parrish, the interpretation should be that as long as citizens accept the state as a legitimate authority on Kantian and Hobbesian grounds, then they will own those actions. And whether I think it's, yes, exactly. I think, I don't think they should make this link. I don't think they should say, yes, okay, so on Kantian and Hobbesian grounds, we will accept the state as an authority. No problem. But why do we have to link this to owning up the action? Because when those actions are... I can see,
But if these actions are within what that legitimizing theory allows, and we accept the legitimacy of the state on those grounds, then to the extent that we do, I guess I'm not seeing what is so wrong with making that connection.
Then I guess, it comes back to, because I was taking this, I agree with, for example, Afia Pasternak's criticism of Stilts, or your comments on her, because simply, we are not really voluntarily concerned, but then at the same time I feel like, okay, fine, but we should accept this framework. If we accept this framework instead of talking about voluntary consent and so on, I still think that it doesn't work because it's not operational, because according to Stilts at least, in some cases and some individuals, some citizens will really not incur liability because they won't accept. And then until they make sense of under what circumstances that I will accept the state as a whole, but then you but not in these circumstances, then you can't say I own up to those actions that where liability is concerned. Are you satisfied?
I appreciate the answer.
Yeah.
I think if we wait until people are satisfied.
Charles Richardson, unaffiliated. It seems to me that if you're relying on a social contract type of theory, there's a radical difference between the way the state can treat its own citizens and the way it can treat outsiders. So if you've got a case of state engaging in massive human rights violations of its citizens, then the citizens can say, well, look, it's acting against the whole rationale of the social contract type state. It's supposed to protect our rights. If it's violating them, therefore we're not in any way responsible for that, because that's not what we signed up for at all. Whereas if it's, for example, engaged in an unjust war against neighbouring countries, you haven't got that same, yes, you may be going beyond the bounds of what the citizens have the right to authorise it to do in the first place, but it's not acting against its original rationale. And so the citizens don't have quite the same way of disassociating themselves from its action, it seems. Like the state can still say, well, look, we're still trying to advance your rights. Maybe we're doing it wrongly or mistakenly or unjustly, but we're doing what we're here for.
Okay.
Does that make sense as a distinction to you?
I think it's a
to me, I
very
think,
good point.
well, so much the worse the social contract theory is the moral I take from that. But
I think it's true again. I think it's a very good point, but I don't agree with the implication of that. So I agree that the social contract theory would have some difficulty in making, sense of not violating the rights of outsiders. When it would be better if they can take account of that. But I don't agree that when the state alleges that it's violating the rights of some outsiders for the rights of the in light of the rights of the insiders, then the insiders will have the right kind of connection holds, and the citizens will automatically be liable. Will be liable for those acts on that ground. But yeah, I don't know why I don't feel that, but
Okay.
yeah.
So let's take a case where we just think about the state for a moment as a corporate entity, which you're happy to do, as you mentioned, I think.
Mm-hmm.
Okay, so the state can be found culpable. The executive state, for example, internally. For example, in the United States, it happened there were no costs imposed, but yesterday the court found the executive state culpable. Not be excessive in legally proper terms, but culpable for having damaged some investors in AIG when they bought whatever happened. Okay, let's not go through the details. Now, they might have actually imposed costs on the executive state. They didn't, happily, in my view, but there was a question of like 400 million was what was being sold. Now, suppose the executive state had been found culpable in that case, and therefore, the administration would have to pay $400 million to these particular investors, which are actually the taxpayers ultimately, I guess, who are paying that.
Yeah.
So an issue that rises there, right, is whether it's fair that people as a whole should have to bear the burdens of what those in office have actually done. That's going to be an instance, I take it, of the problem that you're thinking of.
Yes.
And another instance might be where a state perhaps invades another state or breaches a border or something, and there are sanctions imposed internationally on it, like with Russia. Whether you think they're fair or not, assume they're fair for the moment, assume there was some process of finding Russia responsible for breaching the boundaries of Crimea, and the sanctions are imposed. Obviously, this subject, people in Russia are going to suffer hugely. So the issue is it fair? Now, one answer that says it is fair would be if you regarded those citizens as in some sense authorizing, right, another one being council. What that is, my favorite view would say that they authorize, or they are fairly held, they're fairly punished, as it were, they fairly receives the costs of the punishment, insofar as they were in a position to control what their government did, and they failed to exercise that due control, or they were whatever. And that would be the case of where it's legitimate as a government, and the fairness is. And otherwise, they're going to be bearing these costs of the ill that the government or the executive state did. These are collateral damages, and normally we'd regard them as unfair, but maybe worthwhile, so to speak, in the overall picture. So is that the issue that you're fundamentally concerned with? I mean, as to, well, first of all, is the bearing of those costs, is it fair just when, so to speak, the state is legitimate and the citizens can be taken to have had a control that failed to exercise, insofar as the state acted that way? Or are there other grounds, so to speak, on which you might say, yes, it's fair, they should have to bear the costs, but it's not, the fairness isn't a derivative from the legitimacy of the state?
Okay, I understand your question, but I don't think the question I grapple with is whether it's fair. Okay, actually I don't think fairness matters that much in distributing state liability to citizens. What matters is that, well, you can set that, you can characterize it as a kind of fairness as well. What matters is that when the state incurs liability, and when we are desperate to locate some duty bearers to make good their legitimate claims, the victims' claims, and since the state actors won't be able to bear all the burden, so it's just then we are trying to explain why it were the citizens of that state who bear liability, and I'm saying, the justification proposed by the theory proposed by by Stills and Parrish, it's not a good one. What are the other justifications? What are the possible justifications that would be, for example, control, that the citizens have been able to control their state's act, so that would be much fairer. So because we are distributing liability and responsibility, even moral responsibility, on the grounds of their causal contribution, moral responsibility, the voluntary involvement in it. But even if this is not the case, I think they would still bear liability simply because they're there. To put it simply, because who else are you going to put it very bluntly?
When you say they bear liability, you mean it's fair that they should incur the costs of being held responsible?
I think they should incur the cost. But whether I can say it's a matter of fairness, I'm not sure. I don't think fairness is here to help. I mean, there are many times when, well, this is not ideal theory, so it's like under more ideal circumstances, the state wouldn't be structured in the way it is now, where it's like more corporate nature, and so it's difficult to distribute liability or responsibility following the normal ideas of justice. Or maybe, can I appeal to the idea of strict liability, for example? So simply because you are, you're causally implicated somehow because by virtue of being a citizen in the state, and you incur liability on that.
We've got about 5 more minutes and about 4 more questions, so we won't get to all of them.
So, I don't know if I can phrase this clearly. I think I lost track a bit throughout the talk what the problem was. Initially I thought, and I think it's because you stop talking about the kinds of acts that the state is supposed to be liable for, right? So initially, you said quite clearly that you were talking about rights violations that the state was committing.
Yes.
And I thought, I understand that problem because it seems to me a general problem for a lot of theories of legitimacy, if not all, right? You can't actually hold the citizens liable for rights violations that the state commits because on no sane theory, I think, the citizens can either authorize or empower or whatever or transfer rights to the state to commit rights violations because in general we can't. We're not allowed to commit rights violations. So, you know, that I thought that was kind of the problem you were dealing with, but then it seemed to me you moved away from that problem to something slightly different, the kind of mistakes that states make. So really it seemed to me that by the end the question was, when is it a mistake and it therefore may be a rights violation and when is it not a mistake? So I don't know, I'm sure.
Well, the paradigmatic case will be, for example, the American invasion of Iraq. Yeah. So it's a violation of the acts of the outsiders, so someone might find it problematic. So, I mean, this is Steele's purpose of the essay. Not purpose, I mean, she has this in mind. When she's writing that, she's saying, do citizens, I mean, if, of course this is not the case in reality, if the state of America incurs liability for its war in Iraq, do the American citizens incur liability?
And what's the problem with saying no? It's those people who decided to do that in spite of perhaps having the correct information or being able to obtain the correct information.
My idea is that the American state actors wouldn't be able to satisfy that, to like repay those war reparations, if it's war reparations, to satisfy that immediate demand. Yeah.
Okay.
I think this is probably the last one.
So completely agree that Parrish and Steele's essays is something to be desired. And I'm kind of wondering if you reject completely the equalization model, or perhaps an amended version of the equalization model is legitimate, right? So for example, the case that referendum right in Switzerland, the Wiener case, for example, would that be a legitimate version of the equalization model? Can it be saved, or is it just a bad model altogether? Should we just focus on the Prime Minister's presidency?
Well, good question, but I really haven't thought about that, so I couldn't. But one quick response would be, I think Andrew Beckley's distinction he makes between excusable state acts, state's wrongful acts, and those inexcusable ones is a way of modifying, making sense of this authorization model. So the state is actually performing its role as an authority. It's just that by some fluke, he made a mistake and liability is incurred, and in that case, so that would be a way of modifying the authority model. But I mean, otherwise you really have to discuss why these particular acts of rights violations can count as rights protection, acts of right protection, and that's not something I have. So.
Great. Well, thank you very much, Amy.